the way it has shaped is certainly going to have ramifications, positive ones. Definitely, ripples are going to be there throughout the industry, not only startups, the industry which is not only IT industry, but the entire businesses, the way we function, whether it's social media companies or in fact any industry, be it healthcare or other industries. So it's going to take our center stage now for the next of the decade. So we have the decade, which is as per PM Modi ji also. We are talking about decade and how India will be a contributor there. So we'll begin the session with a presentation. I'd like to share a presentation, sir. This is, if
Yes,
you
ma'am.
can,
The pages are there, ma'am.
would you be able to see the screen? Are you able to see the screen?
No, 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 ma'am.
Not yet. Okay.
Not yet, ma'am. Not yet.
Uh, I hope it's there now.
Yes, ma'am. Yes, ma'am. Now
Yes.
it is. Yes,
So
ma'am.
we
Thank you.
will begin. All right. So now this law, the DPDP, as we call it, was received the presidential assent on 11th of August 2023. And after having the precursor, if you see the earlier bill which came into being, there was a withdrawal of that, and then there was a new bill which was passed, and both houses of parliament having discussed this, and finally this new bill has been enacted. The date of enforcement obviously will depend on when it's notified, and there may be a cascading of different provisions how they will take shape. However, the different dates may also be there for compliance with different aspects of the act, which has been part of the legislation, and it's very expressly saying so. The interesting part about this DPDP is that the whole emphasis is not just to regulate the private sector, but it also applies equally to government. And it brings transparency, openness, and it also brings in a lot of fairness and privacy protection. That was a key concern for a long time in the country. And we are glad that this would not only cater to that, but it also now would omit actually Section 43A of the IT Act and the currently applicable SPDI rules. So they will be now, overridden rather by the new law, and that's what this brings into picture. I just wanted to focus on a brief history for a minute, because we've seen how the Aadhaar judgment came into being, and how the 9 judge bench of the Supreme Court of India passed the Justice K.S. Puttaswamy case, how Justice Shri Krishna Committee came into being. And from there, once the report was launched, there was a PDP bill which was initially called out. Thereafter, the mighty had close consultations on the draft bill. Then it went into Lok Sabha. There were also joint parliamentary committee review for the same. Later, it was withdrawn, and then we had the new DPDP bill for the public consultation. And finally, this has been received the presidential assent, and has come into being as an enactment. Now, if we compare our earlier drafts, just wanted to have a small comparative to show how we have expanded on our horizon rather than having a very narrow vision. It's been very progressive right from the outset. However, this act particularly is very clear in the sense that it doesn't cover offline personal data, first of all. So anything which is not digitized, and anything which is just a personal data which is public, in the public domain already, or something which is only to be used for a public or a personal or a domestic purpose, is out of the purview of the act. So only personal data and non-personal data is not covered. So that's very, very clear in this scope. And also differing from the earlier in, I would say, the bills or the proposals. Now, here, every personal data breach has to be reported to the Data Protection Board and each affected data principal, which is even a higher, I would say, obligation to what we see in GDPR, because in higher risk, very high risk cases, then it would report it to a particular, person who's affected. But because our country believes in protecting, safeguarding and protecting the privacy of individual citizens, we are very, very clear on, even if there's a small breach, we need to notify. And now the central government is, they may exempt by notification, a certain organization, especially from the processing of personal data in certain cases where the law permits, and where there are situations of, say, grave concern, like if there's a threat to sovereignty of India, or defense, or friendly relations with other states, those kind of serious aspects, their exemptions are going to be given by the central government to certain organizations which deal with that kind of a scenario. Now, there will also be obviously procedures and safeguards which will be specified when the rules come out. But having said that, from the earlier, I would say, bills which have come into being, the whole emphasis is now on protecting data in a much stronger way. At the same time, personal data and has to be balanced with rights of individuals. At the same time, it has to have a balance of wherever law requires our data to be processed, then even if there is no consent, in the interest of the individual, of course, or the country, there that data needs to be processed, that exemptions would be provided. Now, as regards right of, say, erasure of data, that has also been incorporated. And though there is no specific provision for harm from processing of personal data, yet the other provisions of law have dealt with it in the sense that there is a penalty provided for every breach. So, in such a way, the earlier bill differs from the current bill, and it's more simplified, it's more easily understood, and it removes, however, the differentiation between sensitive or critical personal data. That is a key change here we see. And the government can restrict personal data to certain countries. The third party country transfer, that can be restricted by notification. Again, it'll be a lot of different factors which will go into giving out that notification, because we believe in sharing data where it is for the benefit or with consent of the particular individual or citizen. And the idea is not to restrict the flow where it is not necessary. So only in certain situations where our country feels that central government is of the view that this needs to be restricted to a particular country, only those countries will be notified as restricted countries. Then GDPR, for example, has a lot of restrictions on flow of data, and it allows you to basically follow standard contractual clauses or adequacy requirements, which are not present at the moment in the current enactment of India. However, there will be reasonable security safeguards which will be notified, and those need to be followed. Now, the regulator, as we see, the Data Protection Board of India is going to be regulator which will be adjudicating the non-compliance issues, and enforcement of the act will be in its domain. TDSAT has been designated as the appellate tribunal. As far as the application of the Act is concerned, we have 9 chapters, 44 sections, and one schedule for penalties for non-compliance. Now, the Act, of course, applies to digital and digitized personal data. So, even if, just to clarify the scope, even if it's a non-digital data at the moment, but it is digitized, that data will fall under the current law. And the processing can happen within the territory of India, even outside India. For example, if there is a citizens' data which is being processed outside India, and they are to provide services to Indians, then that data collection, that processing by the vendor outside India is also going to be falling in the purview of the Act, and the compliance is necessary. Now, that what is not applicable, it's not applicable to processing of personal data for domestic or personal purposes by individuals, and personal data made publicly available. So there, obviously, that will not apply. Key terms, I just want to throw light on certain terms which are very, very important for our understanding here. Personal data, what is this data? not only the name, location of a person or address or maybe financial particulars, but even something like an email address, something like an IP address is also personal data. Now, that would be directly or would indirectly identify the individual. And data fiduciary is a person who alone or in conjunction with other person determines the purpose and means of processing of personal data. So processor will be engaged by the data fiduciary, which will be collecting this data. Data principal is the person whose data is being collected. It could also be a child. So in the case of a child, a verifiable consent of a parent is to be taken before that data of children can be taken. In case of person with disability, again, it will be a lawful guardian. Consent. The most important term in this act is the word consent. Now, consent is going to be expressed, not just that. I'll just give an example. It's not silence which will give consent, that you simply are on a particular website, the website quietly collects data about you and it processes it. Even silence or even automatic consent is not a consent legally valid as per law. So it has to be freely given, it has to be specific, it has to be informed. So for that, a notice has to be given. How it is given? Through a public, say a private, like a, I would say, a privacy policy. It could be in the terms of use as well, and a clear, unambiguous indication that yes, I want to go ahead with the availing a services. You may collect this information about me. That kind of clear affirmative action. It could be by a tick, say clicking on I agree button, but it has to be a clear affirmative action by the individual that needs is needed in terms of proceeding with collection and processing of any particular person's data. Now, there may be certain other areas where consent is not necessary. Now, what are those aspects? They are those legitimate uses under the Act where the consent is not required, like, which doesn't need, say, in case of medical emergency, for if there is a public health threat or threat to a nation, for example, defense or integrity of a nation. Those kind of situations, obviously, you or or if you have to prosecute somebody and you have to collect data about that particular person, that doesn't need consent because those are aspects which are governed by law. So these are required by law. There, that consent requirement is done away with. Consent manager. Now, that is a person who will represent a fiduciary, for example, and whenever there is a collection of data, a data principal, that is a user, can actually ask for information. What data have you collected? Can actually choose to write to the consent manager to correct out that data if it's wrong. Can withdraw the consent and can say that we don't want our data to be processed anymore. So all these situations, or if he has any grievance, can write to a consent manager. Let's go on to seeing in a brief what are the obligations of a data fiduciary. So the companies which collect information of personal data of people, they have to fulfill responsibilities under the Act. So if they're engaging with, for example, a data processor to process this data, they have to they have a valid contract with the same binding terms as, they have to adhere to the same confidentiality norms of collection and processing of data as agreed in, say, for example, a privacy policy with the user, with the owner of the data. So those technical organizational measures which a fiduciary has to put in place, same has to be put in place by the processor. So it's like a back-to-back arrangement. You cannot collect more than necessary anymore. So for example, I know we all download apps from the app store today, and if you have to order food, you say, okay, I agree. If for the purposes of delivery of food, you take my location. But if you don't want this to run, the processing and taking of data more than that, you can say choose not to give access to your phone library or your video library or your photo gallery because these are not necessary. So collection of data more than necessary is illegal as per the Act. And data should only be retained for the time that it is required to be retained. And once the services have been provided, that is not needed, that data should be erased. What should be those time frames? have to be again specified by the government, because for different categories of service providers, they may be different. In case of government, there are certain exemptions as well. For example, if the same is needed for processing even afterwards, it could be, for example, for research, archival, statistical purposes, or where there is legitimate use. There is a requirement as per law, or again for those serious cases where there is a threat to the nation, or defense of India, or integrity of the nation, friendly relations with other states, those kind of areas where this requirement is going to be overriding the privacy aspect of the individual. Now, those are going to be culled out again. More clarity will come, but the Act very clearly already says what are those grounds on the basis of which exemptions can be granted under the Act. Apart from that, the fiduciary has to ensure that there is accuracy, consistency, completeness of the data they are processing, and children's data is very very important, that children that is below 18 years of age, their parental consent, which is verifiable, needs to be taken, and any kind of tracking, behavioral monitoring, or targeted advertising on children cannot be done. So for instance, today in gaming apps, if you see, or various apps which children are using, there cannot be a tracking or behavioral monitoring and targeted advertisements. So those unless there is a verifiable consent of a parent, or they cannot even use those services, say any particular social media app also, or other apps or other games that they may play, or educational videos. There has to be a verifiable parental consent. So that's very very clear. Any kind of tracking is also prohibited. Then comes, disclosures, details of other data fiduciaries and processors. If requested by the data principal, they have to give who they are sharing this data with, and what is going to be done with that data. What is the lawful purpose? And if there is a breach, one has to notify these data principals and also inform the board. The notice requirement is there, clearly needs to say, before taking consent of the individual, what data will be collected, what will be the purpose, for how long it will stay, and if there is a breach, you can contact the DP board, and whatever data is there is going to be only retained for the purposes it has been assigned for, and beyond that it will not be retained. So those are the very clear, I would say, demarcations, or which give that assurance to a citizens that yes, my data is secure and I know exactly what is happening with my data. The problem so far has been that there was lack of transparency, but this data protection act enables, or rather assures and empowers the citizens to understand that these are the clear obligations of data fiduciaries, and if they flout the law, then yes, there are strict penalties, and very very strict penalties rather, almost 250 or 200 crores. That's a huge amount, even for big giants and corporations. Now, what is going to be, the significant data fiduciary? Who is a significant data fiduciary? Is again going to be defined by the prescribed rules, and otherwise, the criteria are laid down, very clearly. For different aspects, we'll have to see who can be a significant data fiduciary. For example, there could be consideration of the kind of data they're collecting, the impact that they may have, what kind of processing they are doing. Does it impact the nation? For example, can it also have an implication on public order? So those kind of things. And volume, what is the volume? So earlier, Bill, if you remember, that significant data fiduciary was defined as having 5 million user base or more. So we don't know what exactly will be the clear criteria on this, but the considerations have already been given by the parameters have already been given by the Act. The further demarcations on that, I would say clarifications will come with the new rules. Now, there has to be a data protection officer to be appointed by the significant data fiduciaries. We have additional obligations. So those, because they handle that kind of volume and sensitivity of data, they will also need to appoint a data auditor. So Impact assessments will also be carried out on a periodic basis by the data auditors. Coming to the rights of data principals now, we've seen what the persons or the corporations who are collecting data, they are accountable, they are answerable to data principals. What in turn does data principal get, and how empowered he feels today as a citizen of the country? The data principle has clear rights, like right to access, right to correction, erasure of personal data, which also has to some extent the right to call for say withdrawal of his consent, right to grievance redressal, right to nominate. So if they want to nominate their entire account, maybe like they can actually pass it on to their next legal heir or a successor. And this right we have not seen earlier bills had, but this particular law has this clear provision. And this may be notice and consent form, for example. They have to be very clearly made out by any organization which wants to comply with the law. Now they will have a clear template for notice and consent requirement, which has to comply with the DPDP rules and the act. And also the act imposes certain duties on them, so it's not only rights. So just to have a fair balance, even data principles owe a duty to be fair, to be honest, and not to impersonate any other individuals, and not register any false complaints or frivolous complaints, and furnish only clear correct data. That's a basic obligation which any data principal owes. So that's something which is very very ingrained also in the act. Coming to the other key provisions, just want to highlight certain very, very interesting aspects, like, what are the, for example, transfer of personal data. Now, that act allows, the transfer of this data outside India, except to those countries which will be specified and restricted by the central government. Further, the Act also has other provisions for other laws which can influence international data transfer. So, the other laws which may apply in tandem will also continue to apply as long as there's no conflict of provisions. In case of conflict, only the PDP Act applies. Right to nominate, I've already discussed. And apart from that, the legitimate uses. So, if consent is necessary, I said, but where it is not necessary. In certain situations where, for example, there is a voluntary disclosure of data by principal, there's a reasonable expectation, by data principal that this will remain confidential. But if there is a need, for example, law requires this to be there, so that needs to be culled out as a clear provision where this is possible, like in cases of emergency. Law requires that this, or the public interest requires that data principals details need to be shared for his own benefit. Compliance with any judgment or any law, threat to public health, where there is a need to ensure safety in case of a disaster like a flood or otherwise, that data can be processed even without consent for legitimate use, of course. So these are certain cases where you know there is a legitimate use per se, and you can see that that is in the interest of the individual also, that this is processed without the need to have a consent requirement. In such cases, it may not be even possible. Now, exemptions. Coming to the exemptions, which are very important even from the government point of view, since we are addressing officials also from IT. If we look at exemptions, processing for enforcement of any legal right or claim, processing for performance of any judicial, quasi-judicial functions by the Indian tribunal or court, processing in interest of prevention, detection, investigation, or prosecution of any offense, and processing of personal data, where the principles are outside the territory of India. If there is any contract which one has entered into with any person outside the territory of India, but the processing happens by a person based in India. But let me clarify here, if it is a citizen's data, say EU citizens' data, now processing of this data principle, any user may be outside the territory of India, uh, maybe based on a contract, and it is done by a person outside India, for a person outside India. But but by a person based in India. So the vendor is based in India. Now, if it is EU citizen data, the GDPR will still apply to us. So that's very interesting aspect, which we also see in many cases. But if it is Indian citizens' data and is being processed outside India, then it will definitely ask for compliance of this law, the DPDP law. Processing necessary for a merger or amalgamation or similar arrangement approved by court, even those cases, exemptions apply. So, in such an these scenarios, which are very clearly given, the exemptions are given from the applicable, provisions of the Act, collection as well as processing. So here we have to see if we fall in the exemptions, then so from certain key provisions of the Act, they may be completely exempted. For example, if there is a necessity to process a particular data of individuals for investigation of a crime or a prosecution, again, it is something which is per se necessary and required by law. So, therefore, these exemptions have been given under the law. What happens in case of a breach? So, if it's false information given by an individual, for example, up to 10,000 Indian rupees, there is a penalty, goes up to 200 crores in case there is no notice given in case of a personal data breach, and up to 200 crores in case additional obligations on significant data fiduciaries are also not, for example, adhere to. But in case of children also, if there is non-observance of additional obligation in relation to children, up to 200 crores, 250 crores for non-compliance of provisions by data fiduciaries. In case of some significant data fiduciaries, there's also a penalty of up to 150 crores and up to 50 crores for provisions which are not specified, in the DPDP Act, but there's been a breach. So there have been lot of different escalations and I would say scales, like we have scales in GDPR. There we see that the earlier bill proposed different penalties. It was about up to 15 crores also it was there, but now, I would see the current the way the strict penalties have surfaced. It's almost at parameter with the GDPR, which even has punishments of up to 4% of global turnover, and that's quite a lot. 20 million, US, I would say euros. That's huge amounts. Those kind of penalties have also been seen in the GDPR. And coming to the exemptions to the government, just one more slide on the same, because we have certain exempted activities which government departments which are dealing with personal sensitive, I wouldn't say sensitive, but personal data of individuals will be exempted from those kind of activities, will not need a consent or a processing for the processing of that data. For example, where the processing of data is happening, where the government entities are doing so in the interest of security of the state and public order, or the processing is for research, archival, or statistical purposes. So we have, say, advised government departments here as well, where there is a lot of public data, for example, collected, and that's personal data. When it comes to archival, research, or statistical purposes, there are a lot of cases where, for example, an individual may withdraw consent. In that scenario, if it is anonymized data, that can continue to be held for research, archival, or statistical purposes. But government departments where they particularly deal with interest and security of state and public order, then even if it is not anonymized in some respect, that can be justifiable, because that is the legitimate exemption which is given to the government under the law. So here we have to see the ground and then see whether that government department, the kind of data it is dealing in, and the kind of activity it is dealing in, and for what reason this exemption, is it applicable or not applicable as per the Act, falling under various categories of what what is the reason for usage of that data. Is it in the interest of security of the state, for example, prevention of say any kind of attacks on the state, or prosecution, or even for law enforcement, or requirements by law. So those kind of aspects, which are serious aspects, and they have been given as a culled out exemption under the act. Now, measures for compliance. Obviously, every organization, be it government or be it a private sector body, wants to know today, what should we do? How do we comply with the law? So the first and the foremost step, which we always say and advise the entities, is to have a clear-cut privacy policy. And the earlier privacy policies which were drafted, they no more hold good, because a lot of things have changed. A lot of rights have been given to data principal. A lot of obligations fall on the data fiduciary as well. So to balance this, privacy policy terms of use have to be very clearly drafted. Then, how does one serve a notice? Not only the draft is important, but how to take that consent, how to take that verifiable consent, for example, in case of children, or what is the affirmative action which will make consent valid. So those are the aspects, operational aspects one has to see. A review of the documentation and what is it used for processing for example, there is no public interest ground, for example. There is a difference in the current law on the basis of which we can process a particular data. So those processing, whether they're aligned with those legal grounds, does it fall under lawful use? All those aspects have to be seen. And the method of obtaining consent being one, how to manage the consent, how to operationalize it, implement the response mechanism, empowering the citizens, how do we inform them of their rights, and in case of grievance, how do we inform them? There's a consent manager needed, appointed by the organization. In case of significant data fiduciaries, this consent manager is a data protection officer. Then having technical organizational measures. What will be those organizational measures? We know that in the current regime, we used to follow the ISO 27001 as a one of the deemed standards for compliance of security standards. Now, there will be more light thrown with the rules and prescribed norms once they are issued. What all technical organizational measures we need to inculcate in an organization? Then revisiting the data processor arrangements. When we say that, the back-to-back contracts between that fiduciary and the processor will have to be legally vetted. So is the contract aligned in order? What you have promised to a user, have you also ensured that your internal contract with the processor is following the same norms and respecting the individual's citizens, confidentiality of data, and maintaining that privacy regime, which is expected from the new law. So looking at that, those aspects is equally important. In case of breach, what is the template for the data protection board? How do you inform the data principal? Those mechanisms, and then also the informing them about the collection and processing, updating the records when there's a request, withdrawing the consent, there is a withdrawal, then there is to be a deletion of that data or service, rendering of the service future to this data principle. So putting all these operational processes in order is important. Then running the data privacy impact assessments where there's a high risk involved. So all these aspects go into compliance, and then having a data inventory checklist, checking the gaps in the lacuna, revisiting the interface, the front end of the service, is it also aligned? The back end is also aligned, and then the notice is available in multiple languages. So we today don't just rely on English or Hindi. We may need a regional language, specifically if you are targeting a particular area or a region for rendering a service, maybe by a government, for example, in case of giving them subsidies or licenses or permits. So those languages, also the translation should be available. Incorporating the age verification mechanism in case those services are targeting children, and taking the parental consent, establishing a unified process for dealing with the consent managers. So what will be the mechanism and within which time frame the consent manager will respond? Undertaking data privacy assessments, especially if we are using AI today. We are using a lot of new software, a lot of chatbots or virtual assistants or chat GPT today. So, are we doing enough data privacy assessments? The samples which we are drawing for creation of AI, do we have enough consent? Even if it's a consent which is taken earlier, do we need a fresh consent? That is what the DPDP Act talks about. And if that processing has, will take place, and there is this consent requirement is not met with, the earlier consent is not valid for the current law, the new consent needs to be taken. So developing data privacy frameworks to strengthen data organizations is important. And the program for awareness, obviously training, deployment of technical software and mechanisms to ensure there's no data leak, those kind of aspects are equally important. Classifying the data, mapping exercises, keeping structured and unstructured data separately, developing inventory of assets, of the personal information they hold, and maybe the same information is used for different purposes, which is lawful, of course, but segregated. So, how they are keeping the data? Are they using anonymity? Are they encryption mechanisms in place? Is the pseudonymization possible? You create pseudonymization principle, for example, for protecting that confidentiality of data. Privacy enabling technology is put in place or not. So these are all governance mechanisms to protect personal sensitive or personal data rather of people today. Now, when we come to significant data fiduciaries, undertaking data protection impact assessment is important aspect, as I did highlight. Having a DPO officer within India is important. Appointing an independent data auditor is important, and performing periodic audits to see if there is any kind of red flag is equally important. Now, coming to just a overview, we've seen what provisions of DPTP Act prevail today. Now, in fact, will be brought into force very soon. How do we compare it with GDPR? That's very important aspect because we're dealing with European citizens' data in India, Indian citizens' data maybe in EU. So it is something like transport or flow of data, and we have to sometimes look at that aspect that we may need to comply with obviously both the jurisdictions law. And in number of cases it becomes crucial for us to understand that our contracts or our policies are aligned and fulfill the requirements of both the laws. So here when we see data protection act in India, it implies only to personal data, excludes public data, as we say, no special categories of sensitivity of data notified so far. But GDPR again applies to personal data. It includes publicly available data and even recognizes special categories of data. So that's a very fundamental difference. And consent definitely is important in the current law in India. Legitimate interests have been defined in a limited way. In GDPR, consent is there, performance of a contract, the data can flow, vital interest of a citizen, data can flow, legal obligation, when you have to meet with a legal obligation, data can be processed. Public interest reasons, data can be processed, collected. Legitimate reasons are broader for the interest of the entity. The service, for example, it's rendering this data is needed. For example, I give you an example of food app. So they need to deliver food. So that's a legitimate reason for them to collect the location data. Therefore, those are the kind of aspects where GDPR has very clearly said that data can be collected with consent for performance of a contract where there's a vital interest, legal obligation to be fulfilled, say public interest involved or a legitimate interest. We don't have those kind of demarcations, but by and large, if you see the current law in India, it has many aspects which are covered under the exemptions or under the grounds, like I said, that consent is otherwise needed, but there may be certain other legitimate interests where it may not be needed. So some of them reflect those provisions when we say medical emergency, where there's a flood, for example, public interest. So those aspects get highlighted, covered in certain ways, the ones which are mentioned in GDPR. Actors involved, yeah, we have data fiduciaries here in India. We have data fiduciary. There we have data controller as a term. Here we do you use significant data fiduciaries there, and There we are talking about data processors. Here also we're talking about data processors who are processing our data. Age of consent, definitely, of children varies here in the two jurisdictions. 18 in the case of India, age of consent 13 to 16 in GDPR. Here we need a verifiable parent consent, reasonable efforts for parent consent required in GDPR. Notice, yes, necessary in India. And when in GDPR we see this, when that data is collected from a data subject and is not linked only to consent. So these notice requirements are floating. Even where there is no consent, you still need a notice to be given. So there, if we see the whole landscape of how this works, retention timelines also are interesting. Give you an interesting aspect of how the law really is enforced. Rules will prescribe this in India. What will be the retention timelines? Controllers in GDPR determine retention period, obviously subject to a justification or the reasonable cause. And breach, all data breaches to be reported to Data Protection Board and data principals in India, whereas in GDPR only risk-based reporting to data principals is mentioned. Cross-border data transfer in India, we can be permitted in all countries except those countries which are blacklisted or say restricted as per the central government. GDPR, it's permitted transporter flow only if there are some additional safeguards like adequacy decision or standard contractual clauses given by the EU Commission, or binding corporate rules, or certain derogations are permitted. So it has a stricter regime in that sense. Consent managers in India have been appointed. There is no grievance redressal really happening in GDPR because directly if there's a breach, you report it to a particular, I would say, authority there, institutionalized there, but you don't have consent. I would say consent managers really are mentioned, but DPO definitely, there will be a right of access updation. So an officer does have to, abide by all those rights and privileges which a data principal has, and the organization has to update the record or withdraw. In case of withdrawal consent, they have to remove the data. Those aspects are there. Penalties vary. They vary from, say, 250 crores in India to about 4% global annual turnover, or euro 20 million, whichever is greater in Europe. And the rights, we have very clear rights. As I said, in India, we've discussed this aspect. And right to data portability, right to object, they have been mentioned in various terminologies there in GDPR. To a great extent, we follow the same here. There is a fine difference, however, in retention of data provisions, because in case of anonymized data, for example, for research and archival, we are allowed to use the data even further. Or in case of legitimate users, certain exemptions have been given to the government here in India. Data portability aspect is not very clearly, said highlighted in this current law here in India. However, the interoperability aspect will need to be complied with, because that is how the citizens' data will get protected. Right to be forgotten, in some ways, has already been part of this current law now in India, because though I would say in the strict term, the obligation actually is on the fiduciary himself to remove the data when it's not necessary anymore to render the services. The timelines have to be notified. At the same time, the individual also can ask for deletion of data, subject to certain, legitimate reasons why it needs to be retained. Potential challenges in implementation. Yes, that's important, a very pertinent question indeed. That we have a lot of set of laws, and there are going to be paraphernalia of how we need to implement the law. But at the same time, there could be some challenges in implementation which need solutions. So here, under the contractual obligations, the law, for example, requires the fiduciaries to process personal data on consent. So how do you take that consent? The need to have the contracts tightly, vetted, legally vetted contracts in place, and whether they can, go under legitimate use when they have collected a particular data and retained it. Those aspects, again, as I was explaining you during the implementation part, that these aspects are very crucial to understand the right way of implementing the act. Now, processing activities or data maps, how the personal data is flowing from within the organization, doesn't mandate clearly, but I know this will fall under technical and operational aspects. So we will have to, explain to the entities that this is the standard you need to follow, and what is our data flow. After all, you have to have that within the organization to seek operational compliance. Then, how do we manage the data principal rights or auditing in larger businesses can be a challenge if that clarity is not rendered. Exemption on classes of data fiduciaries. So, which will be, central government can exempt data fiduciaries or classes of data fiduciaries from certain obligations under the Act. For example, startups may be exempted. So, what will be the threshold? This needs to be explained. Processing of children's data again will be of importance, because verifiable consent, how we need to take it, in what scenarios, and how can we avoid tracking. Those are aspects which companies will be looking into. We have to see obviously the best interest of the child, and the act goes in that direction, that there will be penalties, very strict penalties, if that is not taken care of. So the question mark here will be how to take that verifiable consent, because a lot of times children may actually be giving up, or individual may give false data in terms of age. So that aspect is there. And then other challenges would be absence of a defined timeline for notifying a personal data breach to the data protection board or affected data principal. We know the act exempts certain publicly available data, but can it be used for processing or not, or can it be only for view processes? That's something which we need to understand. And how to respond to a data principal request, maybe the time frames they will need to be culled out. We know that today the law is that within 30 days this grievance of a particular consumer needs to be resolved. So likewise there will be clear cut timelines for the same. And if there's a data breach, for example, under section 70b, we already have a notification by the MIT, which is explaining, in case of takedown there will be, say, 6 hour time window is for explaining the breach, that there's been a breach. And takedown, there has been a very clear guideline to say that it has to be reported and blocked within 24 hours. So depending on the other laws which are also applicable, they would be on the sidelines, which but will still apply. So it depends whether those will be changed, the grievance redressal or the consent manager response, the timeline for the same, or even rather the reporting of the breach. Because right now we have a 6 hour time window, which is by a circular or the notification of MIT. So with this, I would say that I'll stop sharing the screen. I'm at the end of the presentation, but
Thank you, ma'am, for the wonderful session.
yes.
Enlightening
Is this
those aspects.
slideshow over from the screen?
Yes, ma'am. Yes, ma'am. The slideshow is over, ma'am. The
All
slideshow.
right. All right. So I hope this gives you a perspective on how we understand data protection law today, and the new law which is coming into being. The whole idea of giving this presentation today was to decode, as you rightly put the topic, and it's important to understand where we came from. The earlier processes, how the earlier bill was into being, and from the Aadhaar judgment, Justice K.S. Puttaswamy case, clearly says it's a fundamental right of every citizen to have this right to privacy. How the legislation, protects the rights of citizens in the same spirit, and we have a new law now into being, which will not only look at balancing the rights of individuals or citizens, but also looks at legitimate uses where this data needs to be taken and processed even when there is no consent, for example, but in the interest of the nation and the individual. So it's important to see how the implementation will work, the various institutionalized bodies which will work in it for its implementation, and what are the areas which are different from GDPR, what are the areas which are different from the earlier bill, and how the implementation will need compliance, what kind of aspects are important, what kind of steps are needed by the bodies, to be taken. For example, document review, as I said, reframe the privacy policy, don't collect more than what is necessary. Those kind of aspects, which maybe the organizations were not that much cared to understand earlier, will now need to adhere because of the strict penalties we have. And increasing transborder flow of data because of the multinational, I would say, the way the global businesses function today in multiple jurisdictions necessitates this law to be passed and complied with, not to safeguard not only our data, maybe we are dealing with EU citizens' data or other jurisdictions' data. So their local laws also become important. So where do we stand in terms of data protection? We are very, very much at a very, I would say, strengthened position in India now. And there are definitely more areas which will be clarified with new rules and laws which will be culled out, and the bodies which will be framed, the DP board which will be formed. So it has a crucial role to play, and we are definitely at the center stage in the whole global scenario on data protection. The world looks up to us, and I'm sure we'll do a good job in enforcing the same. So, with this, I've also given you in the end the challenges which still remain, and those will be need to be dealt with swiftly by us, and so that we can actually come out and issue the implementation and bring this act into full force. With this, thank you so much. And if you have any questions, I'll be more than happy to answer.
All right, ma'am. Thank you. Thank you so much, ma'am, for your wonderful and enlightening session. I think there are a few questions which are lined up for you.
Sure.
I'll just read those questions for you, ma'am. And what about the past data breaches that may surface now? Whether the data fiduciary needs to be notify the customers now. He is
Yes.
also giving further notification, further information. Says that suppose the data breach was happened in 2020 before DPDP Act, and now it was noticed in the dark web or in the underground forum. Whether the data fiduciary needs to notify to the customers and DPDP board.
See, normally, if you see logically also, any law is breached, any law, if there is a current applicable law in the scenario, like in a country, you cannot ask for compliance or punish somebody retrospectively. Yeah. So unless the law says so. So
Yes.
that's been the normal norm in cases of law. So in case the law is prospective and says so, then only it will be prospective. If it says that it will have retrospective operation, then only it will have retrospective operation. One can't go into a fictional mode in this scenario. However, taking it from a logical sense, if supposingly today the law is brought into force and you come to know that in 2020 there was a data breach, now you can be expected to comply with that law which was existing at that point of time. You did not know at that point of time that 2 years down the line this will be a new law. However, at the same time, there can be an argument that today that this law is now brought into force. So, what is the time of breach? Is it 2020 or today? Or when did you come to know is another aspect, right? So it may even be that if you've come to know today, and today's law says the moment you come to know, if the law, the language is this, that the day you come to know of the breach, you have to notify in 6 hour time window, for example. So then you have to comply. So the wordings are very important for us, that when do we notify the breach. I think this is something which you can't punish somebody for not doing, like for doing something or not doing something when the law is not there. That is very clear. So having said that, the DPDP law, as we will see, will take shape now. We have to inform both the data principal and we have to inform the board as well, right? The moment we come to know of a data breach, that's what it says. It doesn't specify when that data breach has taken place. I think that is the ambiguity. Let me just go on to the act. In fact, that's a very interesting aspect, and I'd like to explore this more. if you give me a second, I would like to, in fact, go on to that provision to see of the data breach myself. Um, it's like, if you see the breach penalties, they're very high. You can't be made make somebody accountable for something that they did not know earlier. And personal data breach means any unauthorized processing. So it's not only say disclosure, acquisition, sharing. It's very widely defined. What is a data breach? It's not just uh, authenticity or integrity of data, which is even accessibility of data is a data breach. So definitely, if you look at it from a liberal point of view, a broad perspective, that you have to take into account it's a very broad vision. And in case of a data breach, this data fiduciary will give the board and each affected person intimation of this breach. Now, in such form and manner as is specified, that is the act. That is how it says. So, what will be that form and manner in which it is prescribed is going to be holding the key to the answer which you're asking me at this point. So, let the rules come into being. But if
Yeah.
you ask from a legal point of view, then certainly it's illogical to say that you will be penalized for something that you did not know you needed to comply at that point of time, because that was not actually required for you to be compliant with. But if the legislation, if the prescribed rules say that it will have a retrospective operation, that you may the breach may have happened earlier, but you have come to know after the passage of this law, you know then it may be. But such a thing like this is usually there in the legislation rather than the rules. It's a aspect which you have to look at: delegated legislation versus the main legislation. So it's a very interesting question which can be looked into more. Yeah,
I think the clarity will emerge once the rules are also published. So let us
absolutely,
have
sir.
some, yeah, some, we'll
Absolutely,
wait
sir.
for some
I
more
think
time to have better clarity, and the rules also will get refined in due course of time based on the inputs and the other things.
absolutely, sir. Those aspects will be
Yeah.
really culled out after the rules come into being.
Yeah, so many of the questions which are being posted in the chat, some of them are actually, I mean, as a lawyer, maybe you can answer, but some of them are still, I mean, to be we looked at after the rules formulation is made public and all those things are there.
Yes, sir.
Yeah.
Absolutely.
So, but in any
Thank you.
case, as a beginner to this, whatever I have listened to from your side, the presentation was excellently, I mean, configured, and you have delivered it in an impeccable style, your own impeccable style, which we are aware. So, I mean, that brought in a lot of clarity on these subjects, which were slightly trickier earlier. And once I have gone through the presentation, it is, I mean, it has made life little simpler for me also
No,
because
thank you
not
so
a,
much for the
yeah,
kind appreciation, sir.
yeah.
I'm
So,
we are always very
and
thankful
in fact,
for.
some of my friends are giving me a message that they would need a soft copy of this PPT. So if you can
Sure,
share,
it would
I
be
will
my pleasure to
immediately
do
get one.
so.
Yeah. So,
And I'm very happy to contribute to this forum today. And it's very I'm very glad that rather happy that you were part of the whole listening, and you as a a very senior person in this field as well. And I'm very glad that we could associate in this manner. And
so
this presentation has been beneficial to the audience. That was the intent. I'm very glad that that purpose is solved today. Thank you.
right. So basically, our idea was to give a little appreciation or the awareness about this aspect. Now everybody has started talking about it, but
Absolutely.
not many people have the bare minimum knowledge or the, I mean, appreciation of the facts. What is being written? How does it compares with the international scenario and all those things. I mean, how you have given an excellent overview of all of that. So
Thank you,
thank
sir.
you so much
Thank you.
for your time. And Jagdish, you can conclude. If there are some questions which we can take it, because these are questions which are, I mean, we can wait for some more time. This is the
Very
first
well.
level, yeah, first level initiation into something which is just been announced, and we are still waiting for the rules to come. So I think questions can wait. Maybe in the next subsequent couple of months, once the rules are formulated, we can have this session again with the rules also being introduced in the proper format, right?
All right, sir.
So
All right, sir.
Jagdish, please take over now. And
Yeah, yeah. Thank you. Thank you so much, sir. Thank you so much, sir. But, thank you so much, ma'am, for your wonderful
Thank you so
speech
much.
on
Yes,
the aspects. And we also heartfully thank Vyas sir for giving us an opportunity to interact, to interact and organize this kind of awareness session to all the employees of the ministry as well as the institutions under the mighty and other ministries also. Of course, like there are so many questions which are lined up, ma'am, but and as sir said, like we have to wait for some more time, then we can clarify those things. Otherwise, we are
truly.
also running out of those things. So once again, thank you, ma'am, for your continuous
Thank
support
you.
for ISC and organizing these kind of awareness sessions to various stakeholders and bringing out various publications in association with ISCA. And we request you your kind support for all our future aspects of our ICA.
As
Uh,
absolutely. Whenever you have called Jagdishji, I've always been, I've
thank
always given my consent, as we call it. So it's my privilege and pleasure to be here, sir. And I look forward to continuing my support to this great initiative ISC is doing and the great work Mighty does. And it's just something that I think we envision that the next decade, as we say, will not only bring this DPDP act into full force and enforcement, but we're also expecting some new legislation may also come up, which are going to support the IT framework here in the country. We have emerging technologies, so we may have some sessions on the new emerging tech, which will shape the contours of legislation and law, as well as the technical world today. So I look forward to that, and thank you for this great forum and initiative again. Jai Hind.
you so much, ma'am. Thank you
Jai
so much.
Hind.
And thank you, Vyas sir, for your continuous guidance and taking us in the for leading this initiative at national level. Thank you so much, sir. And thank you so much, ma'am. So, Samam, and you may leave the platform. If you have any questions, you can always write to us so that we will get back with support from the madam. Thank you so much, sir and ma'am.